Hi, good morning. How are you guys doing? I have I went back all the way to the beginning of this case and reread all the early documents, the PCA and everything before watching the latest hearings. Yesterday there was 3 hours of hearings and some real bombshells were dropped. It was crazy. So let me share my screen here. Hope you guys are doing good. Let's see. There we go. So what we have today, get that off of there, is the hearing today just started just a couple minutes ago. So I am recording that so I can take a look at it after this and then share my thoughts later. Oh, hey, I have Lady V hopping up with me.
Hi, Hun. How are you?
I'm good. How are you doing?
I'm good. Let me make sure I have my YouTube muted over here.
Okay, yeah, I don't hear nothing. So, yeah, if anybody wants to hop up and share their thoughts about the case so far, especially yesterday's hearing, it was crazy.
I haven't heard anything, so you're going to have to tell me all about it.
Okay, sure.
There we go.
All right, so let me check chat here. Hey, Corey Carroll, how are you doing? Hello, I'll allow it. Or Stephanie. Good to see you.
Hi, everybody.
Okay, so the hearing today just started. I found, now since yesterday's hearing was 3 hours long, I recorded the whole thing and I was going to do it as a video, but 3 hours.
It's a long time.
Yeah, we're going to do a shorter version of it. And I'm just going to share my thoughts instead. So let me.
Well, I'll be thrilled to get caught up on it. I haven't really looked into it for quite a while, to be honest.
It's really starting to go down now. You know, we're getting closer to the trial.
Yay!
And for anybody that's not familiar with the case, there were 4 Idaho students that were murdered in their home, their off-campus home. And they were Maddie Mogan, Katie Gonzalez, Katie? I'm going to say Katie. I know that's not right. Kaylee Gonzalez, and Ethan Chapin, and Xana Kernodle. Yep. And that was on November 13th, 2022. There's one suspect that has been arrested, but there were some things that came out yesterday that a lot of people jumped all over. And that was the revelation in court that there was additional blood found at the crime scene.
Oh, and wow.
From unknown people. And it was quite a bombshell. The judge actually dropped one of them. And, you know, that's the reason why we have the gag order, you know, because a lot of this can't come out yet. And,
sure.
You know, we don't know what anything means. We just don't know. So let me share this here. We're going to start with, okay.
Well, maybe I can pop up with you whenever it's trial time and we can kind of discuss in between things.
Oh, yeah. This is going to be one of the craziest trials ever.
I believe
there were some things that came out yesterday that kind of upset me about Dylan.
Oh,
it seems like that poor girl has been thrown under the bus a million times, you know?
Yeah.
And it's just like, wow. Okay. And because you know how I am about, you know, victims and survivors and all that. So.
Oh, I'm the same way. It pissed me off royally every time they tried to blame her.
Mm-hmm. Yeah. Well, Ann Taylor actually brought up a couple of good points about some things that she said in the first few days, and some additional little tidbits of information that was not confirmed about what she was doing at the time of the murders. So we didn't know. So yeah, I'm going to go ahead and play this. If you want me to stop at any point, just, holler at me. And this is a 46 minutes. Yeah, 46 minutes of just the meat and potatoes of what happened regarding just the DNA portion yesterday. Yesterday was the motion to suppress the IGG identification and a motion for Frank's hearing. So that's what happened. The Frank's hearing part we'll go into second, and that's where more of the bombshells were dropped yesterday.
Do you know when the trial's supposed to start?
August, I believe. I'll go look at the schedule while this is playing here. So yeah, just let me know if you want me to stop at any point.
I might ask you some questions
or whatever. Sure. Okay.
It'll be great to get caught up, man. I haven't heard anything about it in a while.
Yeah, it's been pretty quiet, but now it's starting to ramp up, and we're having more hearings, and yeah, it won't be long. We'll have pretrial and then jury selection and then trial. It's going to happen pretty quick. So.
No, I love.
And this judge is not playing.
Well, I hope not.
He is not
this is
playing.
A serious thing, man.
He's like the opposite of Judge.
Oh, good. Judge was very sweet and all of that.
Exactly.
But honestly, he was too sweet for this trial.
Mm-hmm. And Ann Taylor just walked all over him.
Yeah, I did. I did like him, and he was very handsome.
Yeah.
He was easy on.
You're right.
He was just too easy on everything else too.
Yeah, he was asking questions of the attorneys about things that he totally should have known. It was concerning.
Absolutely. It was very.
I remember going, "What? How do you not know this? You're a judge,
Right.
So, all right. Well, if anybody has any questions along the way, or if, again, I'm just going to open up the panel just in case anybody else wants to hop up here with us and share their thoughts on whatever.
Okay, I'm going to mute.
Me too. All right, here we go.
We are back on the record in State v. Kohberger, CR 0124316665. We are now, I believe, streaming for the record. The defendant is present together with counsel, Ms. Taylor and Ms. Massoff. The state is present and represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. Let's do argument on the suppression of the IGG related matters, and then we can then hear the Frank stuff. That's fine. If that's what you're prepared to argue.
Thank you.
Go ahead.
Your Honor, our position is that the court should suppress the IGG identification and everything that flows from that. This is supported by Fourth Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution. Your Honor, there was no warrant for several phases of the search that led to the IGG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required, none was given, and so this must be suppressed. Your Honor, I'd like to identify the 3 stages, and they are when Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample to Othram Laboratories to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody. The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pull in Pennsylvania, and there was no warrant for that trash pull either. All three of those stages of this case, there should have been a warrant and there wasn't, and this must be suppressed. Your Honor, for the purposes of the Fourth Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold that?
I do not have any cases that hold that, nor do I have any to the contrary that say that's not the case. Your Honor, this is a situation where this identification was done in complete secret behind closed doors, and it's been continued to be a secret. And that should raise red flags for Your Honor about privacy interests that are at stake. The court can see from the various affidavits in this case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. The FBI took over the search, and from there they did things that we have no idea what it is. That entire segment of this case is secret. We have been through several motions to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at. Those have not been produced. In fact, we've been told they don't exist. We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not through the motion to compel process. This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a snip to use to try to identify somebody is more than twice as big when it gets to the FBI from Othram. We don't know how. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Kohberger's DNA sample was uploaded into any of those databases, that his was, like, for example, his own DNA was one that was matched from the crime scene. Not asking whether the crime scene DNA was uploaded, but whether he had, as a, for example, customer of one of these companies, uploaded his DNA.
Well, Your Honor, I don't have the jed.com file. I don't have.
You're not asserting that fact, correct?
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to complain about the searches of the databases, because as the state has posited, that wasn't his DNA that was searched. At best, it was his ancestors.
Let me see if I can boost the volume up here. Give me just a second. Let's see. And welcome, Georgia. How are you doing? Well, volume's all the way up here. Volume's all the way up there. The volume's all the way up. Let me try something over here. All my volumes are all the way up. Don't see any other options. How quiet is it? Lady V, is it too quiet?
I hear it really good,
Okay.
but I have an earbud in, so
Okay. Yeah,
maybe
I
you
can
can
hear
add an
some too.
extension for, I got the Volume Master. It's a booster. It's an extension.
Uh-huh.
Maybe you can add an extension to it later, just in case we need it for the trial.
Yeah, yeah. Send me that. Send me that. Okay.
Are you on
Right.
Chrome?
Yes.
Just go to Chrome, go to the Chrome store, and just put booster, and you'll see it. It works great. It's called Volume Master, and you can get like up to 500 times loud.
I'm doing it right now. Hang on.
Yeah, it only takes a sec.
I see it. Okay.
And then just pin it to your extension bar.
Oh, neat. Okay.
Now you got turbo boost.
Oh, cool. Okay. All right. Let's see here. Okay, 626. No, 626. Yeah. It's having me reload. Just a moment, you guys. Okay, 626. Okay, and let me see if I've got the booster up here in the taskbar now. Where's it at?
Yeah, it's just
Little
like a
icon
little.
side.
It looks like a little volume thing. Go to your extension and go down, and then you'll pin it to your extension bar.
Okay.
We might have to turn us down. I don't know. Yeah, but if you go to like the little puzzle piece and click on it.
I can see it. I can see it. It's just not letting me pin it. I mean, just a moment here. Oh, there it is. There it is. There it is. Awesome. Okay, cool. I got it now.
Okay, guys, let us know if we're too loud so we can turn our volumes down.
All right, I'm going to go ahead and mute us again,
Me
or
too.
mute me, and I'll put it back on the screen and we'll boost it. This is cool. Well, I'm glad you said something, Georgia. I just learned something today. Let's see. Let me see here.
I apologize. I wrote the name down, but not the site in my notes, but I know it's cited in our briefing. I can't remember what page. It is 690 F 3rd 226.
Sounds good to me. How about you, Georgia?
And so those are the three areas that we believe that there should have been a search warrant and there wasn't. There is an expectation of privacy in one's DNA that society is willing to recognize. And I think I'd talked to the court a little bit about the things that happened in this case that were super secret. I think we'd gotten to the point where we were talking, and this goes to recognizing an expectation of privacy when there's all of this secrecy surrounding it. We had gotten to the FBI where the SNP profile was twice as big as that from Othram. And then the FBI went into databases that violate the Department of Justice interim policy. You heard a lot about that Department of Justice interim policy, and that policy it's on page 6 of that particular exhibit that the court has. It says that they're not to go into databases that aren't allowed. And they did that. The court has that in another exhibit.
How's that a constitutional violation?
Your Honor, it goes to privacy.
Don't suppress for contractual violations or even statutory violations.
I'm not suggesting that we do that.
Okay, so I want to go ahead and comment right here what the judge just said, because I think a lot of people couldn't quite hear it. And is the volume better, Georgia? Oh, awesome. Okay, good. Okay. So what he just said,
You might
you
want to
can't
turn your mic down just a little bit, though.
turn my mic down just a little bit. Okay. Okay, here we go.
Much better. We got it.
Okay, is that better? Am I still kind of loud?
It sounds good to me.
Good now? Okay, good. I want it to be, listenable for everybody. Okay, so what he just said there, you can't suppress for contractual or terms of service violations or privacy violations anyway. And a lot of people I've seen have been talking about this as being Bryan's DNA that they're talking about. They're not even talking about Bryan's DNA at this point. They're talking about DNA that they got from the trash, which was Bryan's father's DNA.
Yeah, his dad, yeah.
And so he has no standing. It's not his DNA that they even used from the trash. And this is the point where the judge starts stepping in and asking some questions, some really good ones. But just to recap, she's saying that there was no warrant issued for the IGG work on the S&P profile. No warrant for the work done by FBI, and no warrant for the trash pull they did at his parents' house. So, as we all know, it's just pretty much common knowledge. Once you set your trash out there at the curb, it's public property. Anybody can go get it. There's never a warrant needed. However, she's trying to, in one of her motions or her memorandums to support her motion to suppress, she apparently, because she speaks about it here in just a minute, brought up the fact that they live in a kind of like a, maybe in, how to put it? She worded it better than I probably could. They live in a, what is it called? I remember exactly the way she described it, but they have rules, for where they have to place their trash for it to be picked up, as we all do. I can't go and put my right. You can't go and put your trash on like up on your property in the middle of your front yard, because they won't get it, right?
Right.
It has to be on the curb, facing a certain way. We all know the rules for our neighborhood.
Right.
We know when to put it out and how it should be put out there. Can't put a couch out there. Can't put boxes out there.
Now, let me ask a question.
Policies from the companies, and she's trying to use that as saying, well, they were forced to put it out there at the curb, so they should be able to claim privacy to it.
No. Also, if I remember correctly, there were surveillance flying around above the area.
Mm-hmm.
And didn't he put it in the neighbors?
He put his DNA. He had little Ziplocs and stuff that he put in the neighbor's DNA. He was trying to keep his DNA separate from his family's, not realizing that all they needed to do is get, moms or dads from the trash and still track him,
Right.
And
so his DNA wasn't even in there.
Right.
For them to get, is my point.
Right. The night that they arrested him, he was wearing gloves. He was separating his trash from the family's trash. He was doing everything he could to keep his DNA out of that public trash.
I can't believe he put it all in little baggies. That's just obsessive.
That is crazy. So, she's saying all this work by this the FBI was a giant secret. And let's see. Now the judge is about to ask some really good questions, so I'm going to go ahead and continue playing it here.
Yeah.
So I really like the questions that he asks to. I think it's coming up right here in just 2 seconds. Yeah, here we go.
I'm suggesting that that's information that's pertinent to this court in making a very important decision as to whether somebody's Fourth Amendment rights were violated, as well as Article 1, Section 17 of the Idaho Constitution. The purpose of offering that information is because there's a policy, so there's a recognized expectation of privacy in what's contained in a SNP. In a SNP at all, there has to be a warrant to search these types of things, and there wasn't. There would be no need to have any policy if nobody cared about this. The court heard about the different IGG databases that changed their rules in terms of use after a different case used IGG to solve it, because people don't expect to have their DNA searched.
That was the point of my question about whether or not Mr. Kohberger's DNA was in any of those databases. In other words, did he submit his DNA and said, I don't want law enforcement to look at it?
Your Honor, I don't think that that's the way the question should be looked at. I think the question should be looked at in the way that we always look at warrantless searches.
Got to be a standard.
Your Honor,
He's like, there's got to be a standard. There's got to be a standard. And he's absolutely correct.
She's
You
trying
just-
to she's trying to bully him like she did JJ.
Uh-huh. Yeah, for sure. And he's just like shrugging, like, but I don't know where you think you're going with this. Kind of like you're wasting our time. Several times during the day, he literally put his hand up like the palm thing. I was just like looking down, shaking his head like, I can't believe I'm having to sit through this shit.
Oh, this is going to be fun with him.
Oh yeah,
watching.
the trial. Oh yeah, he's
Yeah.
not playing around.
No, he's
And-
not.
And I think this is the moment where she realized she should not have done the motion to change venue.
we're here because the state has alleged that a single piece of evidence ties Mr. Kohberger to this case. They've alleged that there's a knife sheath that has DNA that they allege matches Bryan Kohberger. He's now been incarcerated for 2 years, facing capital murder. I'm not sure, unless we're shifting the burden to me, what else I can say.
Well,
Well, and I'll let him respond, but it is her burden. This is her motion. When you file a motion, it becomes your burden to prove what you're saying in your motion. And she said twice now, oh, this feels like burden shifting. It is. When you file a motion, all the burden's on you. In whatever case, doesn't matter. Civil, criminal, whatever. You file a motion, you got to prove your case. So she shifted the burden onto herself.
you have a burden of showing that the items ought to be suppressed.
This is a warrantless search. There's no justification for this search.
Right. Assuming a warrant is required for this type of inquiry.
Well, Your Honor, we think it is. And we think it is based on case law, third-party doctrine case law. That's Carpenter. Thinking about cell phones, that's the Riley case. If you have a cell phone that gets taken at an arrest out of a car, a subsequent warrant to search the cell phone is required. So we think a warrant was required for these subsequent searches. And there was no warrant in this case.
But by searches, she's not talking about searching a car, searching a house, or searching his phone. What they're dealing with is the search that was related to the trash, the DNA found in the trash. The trash became public property. Literally, she has no standing. She even said, he said, do you have any cases that you can cite? And she says, let's see. No, she has no cases to support her claims. And then she threw in, but I don't have any to contradict my claims either.
Then move on. Move on.
Then move on. Right.
There's an expectation of privacy.
I struggle with, I struggle, to be frank, and where you're going to have to try to convince me, I guess, is I struggle with the idea that DNA left at a crime scene, that there's any expectation of privacy by someone who leaves DNA at a crime scene, that DNA can't be, as you say, searched without a warrant to establish identity.
Well, Your Honor, I don't think any of us can go out of our houses without leaving DNA all over the place.
Not go to a crime scene.
The question,
Boom. I need a boom sound.
Mic drop.
Let me boost that audio some more. Oh, hang on. That's the wrong tab.
of how
Hold on. Where's that? Here it is. I've got it up on 500 and let's go 50% here. I just love what he just said, though. Will not go to a crime scene.
Here. Mic drop.
Exactly. There you go.
how something gets somewhere, that's the subject of the trial. I think the Carpenter case is really instructive for the court here. And that case was about, it was about third party with cell towers. And there was a concurring opinion in that case. I think that's instructive. We leave DNA everywhere. If you carry a cell phone and it uses the towers, there can be a trail of where you
Fingerprints
went.
everywhere?
I'm sorry?
Don't we leave fingerprints everywhere?
We do leave fingerprints everywhere, but I would say, Your Honor, that things like your movements, cell towers, the contents of your cell phone, those are really personal things. That's how you.
Well, Ann Taylor, they did have warrants for everything related to all the other searches, every other search other than the DNA out of the trash. And no warrant is required to investigate DNA, fingerprints, or anything else left by a, possible perpetrator at a crime scene. Have you ever heard of such a thing?
No, and the list killer they caught because he deposited a piece of pizza in the trash and they picked it up.
Exactly. Yes.
Because it was now public trash.
Uh-huh. And they do that all the time. Even people who work in the genealogy field that, say, I can hire somebody and say, I think that man's my father, right? And they'll follow that man until they can, see him drop a cigarette butt or a cup or something, and they'll take it because it's public. They can do whatever they want with it, and then they'll do a DNA test on it. They do that
I was
for all kinds of cases.
I was in a chat one time and we were talking about all of this. And there was a lady that said she actually had to kind of clear her name because she had driven by and she had thrown out her cigarette butt and it was a crime scene area. Didn't know it, of course. And they tracked her down through this stuff and checked her out.
Yeah, she wasn't also driving around, circling around a crime scene
Oh
either.
no,
Right?
but I'm saying once it's out there, dude, it's out there.
They can find you.
Yep.
And I think this should serve as a warning, to people. They're going to find you. Technology is up there now.
There's no way of hiding anymore, in my opinion.
There's a lot of unsolved crimes, unfortunately, but
Yeah, but the better this gets, there's a lot of crimes there's a lot of things I have heard, like even 60-year-old crimes are now solved because, or if they found out who the person was because of DNA.
Yeah.
Which is just crazy.
And they do it by IgG.
Yep.
So I think that's a wonderful new tool that we have.
Oh,
Okay,
me
here we
too.
go. Try not to interrupt this too much because I want to move on to the
Oh, I'm not going
more
to,
of the.
babe. I'm not even going to
You're
talk every
fine.
time you talk.
Oh, you're fine. You're fine. I want to get through this because I want to get to, the additional DNA that they found at the crime scene, which was, I was like, what? I had to go back and watch it a couple of times. Here we go.
Carry out your business. That's how you go. You drive your car to go to the doctor. Your cell phone's hitting on those towers. DNA is even more personal than that. The tests are so different than they used to be now. It can pick up all kinds of information. It takes very little DNA. DNA lives on surfaces a lot longer than fingerprints live on surfaces. So without more, they're not much of an indication of anything. There's a warrant requirement to protect people from unreasonable searches. And that's what we're asserting here. There's so much information contained in your DNA, and you can't stop from shedding that when you go out of your house. None of us can.
Good
To
morning,
be able
Alan.
to have that searched without a warrant could put anybody in jeopardy. There's no privacy left. If that's going to be the standard, you put it in public so it can be searched. That can't be the standard. That would erode the Fourth Amendment.
But that is the standard, Anne. If you put it out in public, if you throw it away, it's public property. Period. And the judge is not buying this at all.
Our position is that there is an expectation of privacy that society is willing to accept. Our position is that there's case law that supports this. Maybe not exactly directly on point, but the court talked about one of the cases that we cited that's similar. It's out of Washington. In that case, it keyed on whether the database was a voluntary, law enforcement can search this or not. In this situation, that's not the case. You know from the exhibit you have and from the testimony that you heard that the FBI went into 2 databases that they weren't permitted to search. So if the court wants to go clear to that extreme, and the court shouldn't, the court should look at the Fourth Amendment. The court should look at expectation of privacy. The court should look at the 3 places there was a warrant required and it wasn't given. But if the court wants to go all the way down to whether or not there was a database searched where the people consented to have their DNA searched, our case is different. The FBI went into 2 other databases and searched those. There was nothing else happening until that happened. And it's instructive, I think, and important for the court to think about how secretive this all was. We are months from trial, and we are learning things about how the government identified Bryan today in open court when we've asked for those things. There's a reason why there's so much secrecy. That's because there's a violation of privacy rights. That's why there's so much secrecy. Your Honor, this is an extremely important motion, and the court is going to decide whether we do have any expectation of privacy left.
Yeah, this judge is bored. Hang on, I'm going to show you all one of the screenshots I got of him. I was just cracking up. Just a moment. Here it is. Okay, there we go. Look at this. He did this several times. Poor guy. He did that a lot during this hearing. Oh my goodness. Okay, hang on, let me close this out.
Oh, just a second. Put it back up there. I went to get coffee. I texted
Oh.
you.
Oh, you texted?
Okay. Oh my God. I think he's going to do this a lot. And
Yeah.
that is funny. Oh my God.
It reminds me of the scene in Mrs. Doubtfire where he says, "Do you ever want to take a freeze frame moment of your life, stand back and look at it?" Or no, he said, "Do you ever want to take a freeze frame moment of your day, stand back and look at it and think, this is not my life."
That's funny.
Poor guy.
guy.
Okay, let me get back.
He's
me
going to
close
be
this
doing a
out.
lot of this with this girl.
Yeah. Okay, back to Diaz.
Or not. The IGG evidence in this case should absolutely be suppressed.
I suspect the state's going to raise an issue that you may need to respond to, but I'll let you respond to that if they do raise that issue.
I'll be prepared, Your Honor. Thank you.
Do you think maybe he's flipping her off?
Oh, I wish I could zoom in on just that. That's funny.
It is
Good
funny.
catch. Okay, so the state gets up there. Let me mark right at state. My state notes. Here we go. Okay. So basically, all this guy is gonna say. Well, I'll wait. I'll let him talk, and then I'll just kind of recap it for everybody real quick.
Thank you, Your Honor.
Why should I permit evidence obtained potentially by searching databases that by its own policies, law enforcement said they wouldn't search?
So a couple points on that. First, even assuming that that's all correct and that they violated the terms
Seems to be the evidence.
the terms of service, Your Honor, don't affect the Fourth Amendment. The terms of service, and certainly Mr. Kohberger does not have standing to raise a violation of the terms of service. And even if he did, the remedy for the terms of service is not a violation of the Fourth Amendment. As we argued in our brief, the individuals, and as came out in testimony today, the individuals who are utilizing these databases, and we're talking about millions of them, are willingly sharing their information with each other, with millions of other people.
Isn't there a subset that says, but I don't want these people to look at it?
In some of the data,
The FBI, as I understand the evidence, then says, okay, we agree, we won't search those ones.
so I'll address that part, but on the database piece, the issue is that no one sharing this information with millions of other people could have a reasonable expectation of privacy. The test for that isn't, do they have a reasonable expectation of privacy against law enforcement? It's against the public writ large. So for example, we cited in our brief 3 different cases where Idaho's appellate courts have found people have given up a reasonable expectation of privacy in information that was shared with a single company. And it was shared with that company just so they could get the service from that company. Here, we're talking about people sharing it not just with the company, but with millions of other people, because sharing it is the purpose of providing it to the database. So regardless of what the FBI did or didn't do in terms of violating the terms of service, no one has a reasonable expectation.
Is it different if they share it with the company and it's obtained by lawful process from that company versus going in the back window and taking it?
No, Your Honor, because right now what we're asking is not reasonableness of the search. Right now what we're asking is there even a reasonable expectation of privacy? And so
That was a very good argument by the state. We're not talking about even Fourth Amendment right, where Anne's trying to twist it into a Fourth Amendment violation. And she also cites Article 1, Section 17 of the Idaho Constitution as well, by the way. It's public once you put it out there. Either if you leave it at a crime scene or you leave it in the trash, it's fair game for law enforcement.
the fact that no one has a reasonable expectation of privacy in those databases.
Ellen, you're killing me today. I know, like, just shave it already. Own it. Not a
Do you
big deal.
remember, who was it? The guy on Popeye, you know, he was always like, I'll give you money tomorrow for a hamburger today. Wimpy.
Wimpy,
Didn't he have
yes.
that?
No. Oh my gosh.
This means that even if the FBI violated those terms of service, no one has a Fourth Amendment right to complain, and certainly Mr. Kohberger doesn't. He has not asserted factually or through evidence that he was a customer to one of these databases.
And that is true. I noticed that the judge actually asked Ann 2 times if Bryan Kohberger himself was a customer at any of these websites. I am what I am. So he doesn't even have a standing. It's third party. His dad, not even him. Actually, I think it's a great aunt or a great grandmother or something that they kind of started tracing down, some cousins, and it's amazing how they can do that.
You know, I have to say, it's going to be very nice sharing this trial with you, with your knowledge and experience of working in a law office.
Thank you. Yeah, you too. You're very smart. You're very smart.
Oh, well, thank you. But you have on the job training, so it's going to be very nice sharing this with you.
Well, it's kind of like because I worked at a criminal defense law firm, I learned a lot about, you know, what's
Well, you
allowed.
can't help but, yeah.
Yeah, it's like I saw how you criminal defense lawyers will throw everything they can at the wall to see if anything will stick. That's just what they do. It's their job. They have to. Because if they don't, and they don't preserve everything possible for an appeal later, then that client can come back and say, oh, I had ineffective counsel. And they will win. So Ann Taylor is doing her job. She's doing her job very, very well. And, you know, I think it's great. Everybody should have, if you're accused of something, everybody should have an Ann Taylor. Everybody.
Well,
Unfortunately,
yeah.
that's not what people get. They get public defenders whose paycheck signed by the DA.
Right,
So,
and they should, because their life is on the line, number one. You want to make sure every time she brings something up, it is ruled on, that's one less thing that they can appeal on as well and get it turned
it's
over.
one less thing that Bryan can complain about later.
Exactly.
She's protecting her own butt with a lot of this stuff.
Well, that's
what
true.
it's really about. That's all it is. Protecting the record for appeal. And she says it a couple of times during this hearing. And the judge corners her on something. I'm not sure if it's in this clip or not. But yeah, he's basically telling her, yeah, I get it. You're just trying to do this, you know, to cover your bases for appeal later.
And you're very fair and balanced in your analysis as well.
I try to be. It's like common sense, you know, kind of tells you which way something's likely going to go. But I'm not a pro-burger. You know, I'm not like, I'm not one of those that believes that the state has no evidence and the PCA wasn't enough and, you know, to convict them, because people don't understand a PCA is just probable cause to arrest. It means a crime did occur. Here's the crime, and here's who we believe based on what evidence we have as of this date. It doesn't mean forever, just as of the date of the PCA. This is some of the stuff that we have. It's not all that they have. It's just they connect those dots and say, this is the person who likely did it. Here's our probable cause. That's it. That's all it is.
Also, our thoughts and opinions should change if the facts present otherwise than what we believe. And
oh, thank you, Ellen.
And I'm that way, and so are you. So
yep. And if he didn't do it, or if there is somebody else involved, which you're going to hear about in just a little bit about additional evidence that they found, you know, I want anybody and everybody that's responsible for those 4 people who've lost the whole rest of their futures and their family's futures. You know, when you lose a child, you're not just losing your child, you're losing your child's child. You know, you're losing your future grandchildren and their whole lives. You just cut off an entire, you know, limb off of your family tree. You've lost all of it.
Well,
And
if we don't, justice isn't actually served in that either.
exactly. So if he didn't do it, or if he didn't act alone, I hope all of the truth comes out, all of it.
Absolutely.
Which is why I went, what? When I heard what Ann Taylor said. And I have a couple of questions about it too when we get to that part here.
Okay.
And maybe that changes the case if he were, but he's not. He's not even claiming that. He's not even asserting it. Now, I do want to address the second part of the court's question about the FBI has indicated that they wouldn't do this. I believe that's a reference to the policy we've been discussing, the interim policy by the DOJ. I certainly do not speak for the Department of Justice. I do not work for the FBI. I'm speaking for the state of Idaho, but I can read a document, and if you look at the policy in footnote 1, it clearly says this interim policy does not impose any legal limitations on otherwise lawful investigative or prosecutorial activities or techniques utilized by the Department of Justice, or limit the prerogatives, choices, or decisions available to or made by the department in its
You're fine, Ellen. I love talking with you.
discretion. In other words, their first problem is they're relying on a policy at all. The U.S. Supreme Court has said policies do not equal Fourth Amendment violations. Their second problem.
Very important to note what he just said. I'm going to go back. Just a second.
Problem is
right here.
Their first problem is they're relying on a policy at all. The U.S. Supreme Court has said policies do not equal Fourth Amendment violations. Their second.
The U.S. Supreme Court has said he can't go against it. It's the Supreme Court. He has to abide by the Idaho Supreme Court and the U.S. Supreme Court. The U.S. Supreme Court, which is the highest law in the land, has said that policy violations are not, let me see here, put it down. Oh, Lord. Okay. I had a mark on it. I take so many notes while I'm watching these things. And here it is. Policy violations do not equal Fourth Amendment violations or constitutional violations, period. They just don't. So right there, in that sentence alone, I think the state won, just right there.
Second problem is it's a circular argument. The policy doesn't say you cannot do any of these things. It's saying best case scenario, you're not going to do these things.
Well, if you were interpreting this as a matter of contract, wouldn't you have a problem in the sense that on the one hand it says don't do this, and on the other hand you've got a more general sort of catch-all that says, but we're not really meaning anything we say?
No, I don't think there's a problem interpreting that at all. I think the problem is they are putting way too much weight on this policy as if it's somehow the law. And it's not. It's indicating, and we heard testimony today about best practices and what those mean. This is indicating best practices, but very clearly stating we are not limiting the Department of Justice to have to follow what's in this document as long as it's not limited by the law. And they're trying to use a violation of.
I am going to use our HOA as an example, just anybody's HOA. Your HOA and the neighborhood that you live under, if you live under an HOA, your HOA can't put anything in their bylaws that violate your right. They can't put anything in the bylaws that violate city ordinances. They can't do city ordinances for their part. They can't put anything into state law or city law or county law that violates state laws. State laws can't put out any laws that violate federal laws. It's like it's a trickle up effect, you know? And for example, like my HOA can't say, we can't have pets at all. They can't bar that. They can't say you can't have children. They can't say you can't have a same-sex family. They can't do anything that violates your rights. They can't say you can't have a car that's less than 10 years old. They can't do that. They just can't. And just like he's saying, Ann Taylor can't claim that a policy violation is in any way a violation of his constitutional rights, because it's just a policy. It's not even a law. It's just a policy. I mean, I give her credit for trying, but it's just not going to work. It's just not. And I love this for the state. I really, really do, because now granted, they wouldn't throw out the case. He probably wouldn't walk out, but it would create huge problems if a policy of the DOJ could interfere with these warrants, because we're talking about the AT&T 1 and AT&T 2 warrants. They want those thrown out, and the IGG. If all those were thrown out, then there would be almost no case. They would still have identification of Bryan Kohberger, but they wouldn't have anything else attached to that. They wouldn't have all of the cell phone records, all of the AT&T records. They wouldn't have the Amazon warrants. All of that stuff would be out, because then it would be, some of those warrants are like fruit of the poisonous tree. So they would win huge if they won any of these. And that is why Ann Taylor's pushing so hard for the suppression. I get it. It's her job, but it's just not, it's not going to fly. No way. Your cat walked on your keyboard?
Of this policy, or an alleged violation of this policy, to say that they violated the law. It's circular reasoning. But despite all of that, the U.S. Supreme Court has said a policy violation isn't sufficient. Even the Department of Justice, as powerful as they are, they don't get to rewrite the Fourth Amendment by changing this policy. Now, I do want to address, the defense is they're trying to pick and choose what they believe the searches are throughout this chain. And what they're leaving out repeatedly is where this DNA started. Where did the chain start? Well, it started at a quadruple homicide, at a crime scene. There is no case law anywhere that the state could find, and the defense has not cited any to suggest that there is a reasonable expectation of privacy in DNA found at a crime scene. And I want to talk about the Davis case, Your Honor, because it actually cuts against the defense. Davis is the case where it was a very unique set of facts. There was an investigation into a shooting. An officer went to the hospital, and when he went into the victim's room, he saw a bag of clothing. He seized that clothing under the plain view exception to the warrant requirement. So the clothing wasn't abandoned. This was an exception to the warrant requirement. Later on, this individual who was a victim now becomes a suspect, and they have this DNA and they test it. And the Fourth Circuit said, no, you can't do that. You can't take it because he's a victim and then later use it against him as a suspect. That is nothing at all like what we have here. And in fact, if this court looks at the district court opinion that was affirmed by the Fourth Circuit, it expressly states nothing about this holding is indicating that the government needs to get a search warrant for crime scene DNA. That does not support their position. The Achilles heel in their entire chain argument here is that there is no case anywhere that suggests that a DNA analysis restores a reasonable expectation of privacy. So in the Davis case, no one lost their reasonable expectation of privacy. It was seized pursuant to the plain view doctrine. The other case that they're relying on is that recent Supreme Court decision from Arizona. They attached it to their reply. That case is similar to Davis in that the DNA was collected from someone who consented to it under a statutory framework because they had to provide 2 vials of blood so it could be tested for alcohol and drugs. Again, that case would have come out differently had the 2 vials of blood been found at a quadruple homicide. That is a pretty big factor in deciding whether or not someone has a reasonable expectation of privacy. In Idaho, while this specific issue has not been addressed by the appellate courts have told us what to look for when you're talking about a reasonable expectation of privacy. And it's things like ownership, possession, control, ability to regulate access. Mr. Kohberger had none of those things with respect to the DNA on the knife sheath. We are talking about not just a crime scene, not just a murder scene. We're talking about a murder scene in a house to which he has asserted no connection whatsoever. 4 victims to which he has asserted no connection whatsoever. We're not just talking about his DNA happened to be found in, a dresser drawer or something. It was found on a knife sheath where 4 people were killed by a knife. This is as crime scene as it gets. And that's where the DNA was found, and they can't cite any case law whatsoever. And so they try and just ignore that and skip over it and say, well, let's just talk about the DNA analysis. The other problem they have, as this court questions indicated, is the analysis that was done in this case, as we heard the evidence today, is not something that revealed a bunch of private medical information. In fact, the defense's own expert, who is engaged in the same kinds of conduct as Othram in terms of developing these SNP profiles, said he had successfully developed hundreds of SNP profiles and never once learned medical information about any of those individuals. He testified that he has never even heard of a forensic investigative genetic genealogy case that was solved using medical information. And in fact, and I wrote this down when I asked him what he would need to do to learn medical information from those SNPs, he said, quote, "It would be a lot of research."
Oh no, we're embarrassed. We screwed up. Our warehouse is overloaded with survival food kits, but our mess is your
So
Well, that's my reminder. I need to go. I haven't even been on here. I need to pay my premium. I can't function on YouTube without my premium. Okay, here we go.
We'll talk.
defense is positing this.
Sorry, honey, what?
I said I have a suggestion. We can talk in a bit about that.
Okay,
after.
cool. Okay.
This question of, they're saying the court needs to ask itself, what could law enforcement do with the DNA? And then decide whether or not there's a violation of the Fourth Amendment. But that's not what the U.S. Supreme Court says. In Maryland v. King, they were very clear when it comes to DNA, because the defense there was asserting the same argument. We have DNA. DNA can reveal a bunch of private medical information. And the U.S. Supreme Court said, quote, "Even if non-coding alleles could provide some information, they are not, in fact, tested for that end." So the question under the Fourth Amendment is not, what could law enforcement possibly do with this? The question is, what did they do? And in this case, there is no evidence whatsoever that they did anything to find out medical information about Mr. Kohberger.
Okay, so after this point, Ann Taylor gets back up there and she said that DOJ policy on not accessing unallowed databases was a violation of his right, which, again, not going to fly. And then she's also trying the angle of the possibility or the potentiality of the state getting health information on his family and him through DNA is also some sort of a privacy violation. It's not. They didn't use it for that. Again, he just said there's no evidence that they used. They didn't give a crap about health information. They just wanted to know who it was. That's it. So from there, let's see here. I'm going to go ahead and move over to the other clip. Give me just a moment. And then, because this is where they start talking about the wild information that came out. So this is part of the recording that I did. So I'm not sure if I talked in this one or not, but we'll find out.
Ellen wants to know, what about the neighbor's trash can?
Yeah, that's public too. Yeah, that's public too. And all they did with that was just compare it. They witnessed him. They have that all documented in their surveillance of him doing it. They have all the video. He also says that they have, Anne tried to claim that, what was it that she said? This was such a long hearing. It's why I'm not playing the whole thing. But that it was somehow a violation of his rights by getting his DNA from the neighbor's trash. Same thing applies. It's abandonment, public. So here's where Anne kind of, I think in my opinion, she did it on purpose to kind of slip it out there in public, because she did admit at the last hearing that they want to try this case in the public. And the judge is not happy about that at all. So he's considering just dropping all of the gag orders anyway as we get closer to trial, because there's so much misinformation that has been kind of put out there in little pieces and things that have been mentioned in motions and things that he feels has been, them trying to play to the public instead of focusing on the law. So that's not going to help them when it
No.
comes to trial. That's just not going to help them at all. All right,
No.
here we go. I'm going to play this now. This is where they talk about the other DNA that they found, additional blood, which is quite interesting.
Cause, and then everything else does as well. But let me answer your question there. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe.
So say what now? Let's go back and hear that again.
Told.
Actually, I was going to
There's
ask
unknown
that.
male.
Yeah.
Say that
If you
again.
could go back. If you could go
Yeah,
back.
I had to listen to it like 3 times to really hear what she said. Unknown male B. So there's A, B, C, and D. And she's talking about B and D right here. For some reason, they're not talking about A or C. I don't know why. Probably Bryan Kohberger was one of those that they identified, But B and D are still not, to this day, identified. Check this out.
Wow.
Yeah.
Cause, and then everything else does as well. But let me answer your question there. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more. Maybe it,
Well, I'm just not sure why it matters for probable cause, but I think we're talking over each other, so I'll let you just go on.
okay. I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway because you brought up.
Ooh, here comes the judge now. Because I can tell he was a little irritated by her throwing that out there in the public.
Blood DNA of an unknown individual that was found, I think, on the handrail.
Yes.
Doesn't that necessarily not exclude Mr. Kohberger? What it may do is suggest there might be a potential other person in addition involved if you assume that that blood was related to the victims and not some earlier event in the house.
If what the court is saying is exactly why the magistrate needed to know that. Is there another explanation here? I've got this sheath, but there are all these other things that if I know about them matter. What's the other explanation? What's going on with this investigation? What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence. She wasn't given a chance to ask any of those questions. She didn't.
Unknown male D blood found on a glove just outside the residence.
That isn't that the one that
Chris
who was it
McDonough?
that- yes.
Chris McDonough? Yeah, we don't know. Who, the way she phrases it, she's good. She's slick, right?
Oh, she's not dumb, that's for sure.
No, she's not dumb at all.
She's very smart.
I'm not sure if somebody laughed Ellen or coughed. I wasn't sure. A, B, C, D. Right.
Yeah, but we're talking
That's
about
just
the sheet that was under Maddie.
yeah. That was one of those A, B, C, or D, and I think they
Yeah.
identified, but they don't even bring up C. Where was C? Where was C at? The glove. The way she phrases it, it sounds like if you're just listening, right, and you didn't know about the Chris McDonough thing, the glove that he found was way out there by the trash can.
Right.
Between the trash can and the police vehicles. And I believe that was found after the victims' vehicles were all moved.
I think so.
Yeah, if there's a D, there's got to be a C, right? And like, what is that? Where did they find that? Now, so the way she phrased that, you would think that she's talking about something that's found like right outside the back door. You know what I mean?
Right.
She said just outside the residence. Out at the curb by the trash isn't just outside the residence, in my opinion. So it's not clear to me if she's talking about that glove that Chris McDonough found or if she's talking about a different glove. I don't know. We'll have to find out at trial.
Does she bring up C and where it was found at all in any of
No.
that? Huh.
No.
That's interesting.
Mm-hmm. Yeah, right. That was several days later. Several days later when Chris
Yeah, I
McDonough was
remember
there.
it. Yeah, I remember because he was out walking around that area when he found it.
Mm-hmm. And it was inside the crime tape at that point still, but it was off of the trash can, you know, kind of
Right.
between. So that's not just outside the residence. You would think when by hearing what she just said, again, she's playing to the public, putting that out there. There was glove outside, you know. Yeah, with BHB. Mm-hmm. And I don't put nothing past those people.
No.
I mean, remember, you know, you have to remember that team of people were the ones that planted the water bottle in the Gabby Petito case.
Yep.
They got caught. So, yeah. Yeah. But pretty crazy that this just came out and, you know, several channels have just run with it. Oh, there's somebody else. Somebody else did it and they framed Bryan, you know. That doesn't mean that. If you take a luminol light and you go over your own bathroom and kitchen, you're going to find traces of blood. You're just going to. From people cutting themselves, shaving, cutting themselves, cutting onions or whatever, you know. There's going to be blood in your house.
Absolutely true.
And it doesn't mean that it's connected to the crime. It just doesn't. It could be, but she put that out there. Like,
well, it's like that lady I was talking about that they found her cigarette, but it wasn't related at all.
Mm-hmm. But they still checked it out. Yeah.
Absolutely.
The fact that they haven't identified those other people to put that to bed, you know, they're probably all over it now.
Oh, well,
crap,
yeah.
now we got to identify these people, you know.
In my opinion, they should have identified them a long time ago, to be honest.
Yeah, exactly. I think they should have. And because it was probably just some, you know, sorority dude over there at a party, cut himself, you know, on a beer bottle or whatever.
That was the party house, if I remember correctly.
Yeah, it was quite a social gathering place. And exactly, in a college roommate home, there's DNA all over the place. And once blood's dried, you can't tell where it came from anyway, or how long it's been there. And she also doesn't say, where was it found on the handrail? Was it found deep in a little crevice, like on the bottom? Or was it fresh?
Oh,
was it clearly fresh? She didn't say that. That's
a good thought.
She's smart. She knows she can't add all that detail because she wants that public perception out there that maybe else that carried that knife sheath into the house. You know what I mean?
I agree.
You don't want to run a UV light or a black light over a college bed. That's for sure.
No, I don't think so.
Don't do it. Don't do it.
Know that Bryan's car, and the court's
Okay, so I don't know which. Yeah, this is part of the recording that I did. So I'm going to skip forward a little bit here and get past me talking. Male, the police vehicle.
get to
Was stabbed with said alleged knife that would have been in said alleged sheath. For purposes
it's not Bryan.
Ms. McDonough finding that glove and alerting police to it. And it wasn't right after. I don't remember how long. Do you guys remember how long after that glove
When
was
he
found?
found it was a few days, I
I don't know
believe.
if she's referring to the same glove or not.
Ellen,
Oh, sorry, honey. That was me on my recording.
sorry.
You're fine. You're fine.
Ellen, did
I was
you take a light and shine it on your
You
husband?
didn't. Are
Oh
you
my
serious? Oh my gosh. Oh my word. You're smart. But so there's male A. So she talks about B. Here we go.
Question. Good question. What does that mean? Could it mean there's more than one person? The answer to that is, or it could mean it's not Bryan because his car's got nothing in it and there were only 13 minutes to do this. The magistrate didn't get to know that.
In fact, his DNA is still on the knife sheath, though. That's the problem, counsel, for probable cause purposes.
If that's the only thing she's told, I can see why she'd find probable cause.
Ah, man. Like the judge is like rubbing his forehead, but there's still his DNA on the knife sheath, and that's enough for probable cause.
That's what my brain keeps going back to, and it was under one of the victims, so there's that.
It's right there. Yeah. It'd be different if they found it in a drawer, like the state said. It would be different. It matters where they found blood and
Oh,
DNA. It matters.
absolutely.
So it looks like I'm about to talk again. Here, let me see.
It's these other things that are withheld that create a context around it. I think the purpose of Frank's is to ask this very question, and this is a question. What do we want to do with our criminal justice system? Do we want to have one thing with no context around it when there's this other context that really matters?
The Frank standard, which is even if you add that stuff, does that take away probable cause, counsel? And my problem is once you have a direct DNA tie to the defendant, for purposes of probable cause, this isn't for purposes of conviction, for purposes of probable cause, you have not explained to me why a reasonable magistrate, let alone any magistrate, wouldn't find probable cause there, even if they knew all those other facts. As to Mr. Kohberger, now, there may be, as you say, other people that creates concern or issues about that need to be investigated further. But I'm not sure that that diminishes the probable cause as to Mr. Kohberger if his DNA is found on a knife sheath found on or near the victim who was stabbed with said alleged knife that would have been in said alleged sheath.
She sits there quietly like a deer in headlights for a second. I'm like, crap. Yeah, because even if they did tell the magistrate, yeah, we found this here and this here, they knew who he was. They still had probable cause.
Is this the first
To get
hearing
him.
she's had with him?
No, a couple days ago they had another one over the same stuff. But she appeared by Zoom that time. Yeah. And so they still would have arrested him. They totally still would have arrested him. They just would have, and they probably did interrogate the crap out of him and ask if anybody else was involved,
Well, definitely. I mean, his sheath was under Maddie.
Yeah. And I think that's what probably came out in the Amazon, the grand jury subpoena that she's trying to suppress as well.
Right.
proof of him ordering all that on Amazon is probably in that. That's my guess anyway. We don't
And he
know.
also didn't he also order the for my brain jumpsuit from there as well, if I remember correctly?
Well, they didn't say what it was. They just said Dickie's receipt with tag.
Exactly, Dickie. That's right.
And we don't know if that's Dickie's jumpsuit. I found a long time ago some Dickies black slip-proof shoes that they also sell at Walmart
Right.
for that also has a diamond pattern on the bottom of the shoe that you can buy at Walmart. So we don't know if it was a jumpsuit. Possibly was. Could have been black shoes. Maybe, you know what I mean? And maybe
Yeah.
they found them, maybe they didn't. But
Yeah,
if he
that
just recently purchased some black non-slip shoes that have a diamond pattern and those shoes are missing, where'd they go, Brian? You know?
yeah, and Ellen brings up a good point. I had actually forgotten about the security guard.
Yeah, good point. Okay, here we go.
I think the most prominent question is, how did that sheath get there? And I think when you ask that question, I think you can have DNA on an object at a scene when you know about all of these other things and you don't find probable cause, because there are more questions than there are answers. And all of a sudden, this one thing doesn't look as big. It doesn't look as everything pointing to it when you have the context around it. The magistrate didn't have to have every detail of the case, but knowing how many attempts to find a DNA connection there were, and it didn't exist in Brian's car, in Brian's apartment, that there's no other DNA in there other.
Yeah, even that, like the fact that they didn't find any blood or DNA in his car or apartment doesn't matter. He is a master's level forensic expert, you know? He was going for his PhD in it and a new pose.
Exactly, because
He knew what he was doing and he had access to all of that. There's actually pictures of him at DeSales at a crime reenactment where they did a class on forensics.
well, in
And
my opinion, okay, and this has been my opinion since the very beginning, is I think he was taking those classes to aid and abet him in,
to learn,
yeah. It's
yeah,
not
and
unheard of. I mean, you got BTK, you got Ted Bundy. I mean, they do that.
yeah,
Sorry about the noise, guys.
I personally think that he might have wanted to be that professor grading papers on this crime and other crimes, to be the person who knew the truth and watch
I
people
agree.
talk about it, you know?
I agree. Voyeurism.
Voyeurism, exactly.
Yeah, because, people were going crazy over the food truck thing. And way back then, I was like, why? Because they had, what was it, a Twitch
Mhm.
was where you
Yep,
could go
Twitch feed.
watch it. And
Yeah.
I was like, why would he have to put himself physically there when he can watch that from any place? You know?
Yeah. And that night, remember, I did a live where I showed that Kaylee had her location on.
Right.
So,
Right.
and most of their social media accounts were public.
Right.
Their very last
Exactly.
video showed the layout of the second floor of the house.
Mm-hmm.
Yeah, it was totally planned. At that point, you could pull up their address and look at all the pictures of the inside of their house and see where all the exits were, where all the rooms were.
I
You know?
completely agree. And then you could get on Zillow as well.
Yeah, that's where all the photos were. And it's like you could plan it from far away
Oh yeah, I believe
and then watch
it.
them
I believe it was premeditated.
Yeah, he probably, hyped himself up to do this, with all those loops around the neighborhood, watching and waiting. And that probably wasn't even the first night that he'd done that.
Oh, I'm sure it wasn't.
No curtains, exactly. I mean, these girls, I'm sorry, but
They
you
should have
got
been
to
more
lock down your
careful.
social medias. You can't just live your life public like that.
Well, and you gotta lock
It's so
down your curtains
scary.
too,
Yeah.
I mean, that dog walker guy, he said, he walked his dog all the time and their curtains were rarely, if ever, closed.
And I bet that back door was probably never locked.
Right.
Just not safe at all. But they lived in a very, very small community and they felt safe. They had people all around them. They were literally surrounded by other houses. They felt safe.
Actually, Ellen, I don't think it was that dog that was killed. There was a dog that was, yes, but it wasn't his, I don't believe.
You don't think he did the dog thing? I don't either.
Yeah, I don't think so either.
It could have been. I wonder if something like that will be brought up. But yeah,
I
that sounds,
wonder.
yeah. Oh, they also brought up in this hearing, I don't know if it's in this clip or not. They also brought up the fact that Murphy was found in Kaylee's room with the door open.
Right.
And Murphy had not even gone into Maddie's room where the girls were. And that door was open as well.
Right.
The front door was open. The dog was just chilling in Kaylee's room
It's a good
all
thing
night
he was
by
there.
himself and never
Poor
went
little
in there.
baby. He was
Yeah,
probably
they found
scared to death.
probably, or just super well trained,
Yeah.
And that's
I wonder if he walked around at all and
they said
maybe
the
packed some
state
blood.
said that they found no blood on the dog at all.
Wow.
None.
That's amazing. He was probably scared to death. He was a puppy too, so
Yeah,
he was scared. Poor thing.
poor baby. Man. Okay, let me finish this up.
With an unknown male B that we know of for sure, an unknown male D outside. There's a lot of context there, and all of a sudden this one thing, the question of how is that there is the question that the magistrate should have had. And then we come to all of the other things that we've talked about. We've come to what we relied on. One of the witnesses saying things that absolutely couldn't be true.
Okay, now here comes Ann Taylor with basically bashing Dylan. This part really pissed me off, honestly. Just completely disparaging her credibility. So, trigger warning.
I'm going to run to the restroom real quick.
Okay, I'm going to go ahead and play. Or do you want me to wait for you?
Oh, no, you're in my ear.
Okay.
One of the things that the witness who said these things that couldn't be true also admitted she didn't really know anything. You can't rely on that anymore, so you take that out. The identification to this sheath that maybe seems like it would be really good. You don't really even know how that happened, and you don't know how it got there. This isn't like DNA in blood on the wall from Mr. Kohberger. That's not there.
Yeah, I totally get it. Yeah, I have questions too, and I have even more questions about a few of her comments here about Dylan. Judge hand switch incoming, right? Yeah. There's a few details that she lets out here.
That doesn't exist in this scene. You're talking about an item that the question of how should be, especially when you know about the other male DNA in the house, and especially when you know about the lack of DNA connections. There's also no connection between the people in the house and Mr. Kohberger based on their cell phones, based on social media accounts. There's just no connection. The magistrate wasn't aware of all of those factors when she was being asked to decide on probable cause. I don't think criminal justice means one piece of evidence out of the context of everything else is all you need. Context matters a whole lot.
Well, you're not suggesting the magistrate was told that there was DNA evidence found in Mr. Kohberger's car or in his apartment. The lack of inclusion also can be viewed as the implied of, they're obviously not telling me they found this, and they would have if they did.
I'm not 100% sure I followed. I'm not sure. Are you asking me why I think that's important as far as the Frank's purposes?
Well, for Frank's purposes, you are implying, I think, necessarily that the police intentionally didn't tell the magistrate that they didn't find the lack of evidence in other places, the apartment, the car, etc. Right?
Yes, that's right.
They didn't tell the magistrate.
What I think everybody missed here in this hearing is the warrants for his car and his apartment and his office and all that. They weren't even obtained until he was arrested. So law enforcement wouldn't have put that in the probable cause at that point. It wasn't even done yet. So I don't even know why it was even brought up. Remember, they didn't even go there. They didn't even go to his apartment until the night he was arrested. It was an hour after he was arrested. And the PCA from Pennsylvania was already signed off on. And then they used that PCA to bring it to Moscow for charges there.
Yeah,
the same
that's true.
PCA.
Right.
So why is it even brought up? This part kind of confused me. It's like, of course they didn't even know if there was anything in the vehicle at that point. Yeah, exactly.
Did she say something about Dylan, or did I miss it?
She said that Dylan said the way she phrased it was Dylan admitted she didn't really even know anything. When the exact quotes are a little bit different from that.
Absolutely.
Yeah.
That there was evidence.
There's
This is
more.
a omission.
This is one of the omissions. Yes. Yes, we have false statements and we have omissions both. It's not one thing in this case.
There's understanding complete.
Yeah, thank you for that. I wasn't following the question the court was asking. I think the other thing, I think I covered all on my proffer, Your Honor.
You know, she seemed kind of her lack of confidence at this hearing was astounding, being such a strong, intelligent attorney. I got the sense that she wanted to bring something else up at that point, but then she was like, yeah, it's not going to work anyway.
Yeah,
And
I got the same feeling.
Yeah, like she wanted to say something, but she was like, yeah, I've wasted enough of my energy. I've covered all my bases that I need to. We're done. And then the state's going to get up and explain more about Dylan as well.
Thank you. Sorry.
I think now, Mr. Nye, were you going to address the IGG Franks issue, or is Ms. Jennings going to cover all of it?
Your Honor, I think I'm going to cover all of it.
All right, go ahead.
Gonna attempt to. Good afternoon, Your Honor. As you're well aware, You have to make two separate inquiries for each of the claims that Ms. Taylor has brought before you. First, you have to decide today, has the defendant made a substantial, not just a preliminary showing, but a substantial preliminary showing that the affidavits, and in our case, we're referring to the Exhibit A's that were attached to each of the affidavits for probable cause, that they were the basis, which were the basis for multiple search warrant applications, that within those Exhibit A's, there were deliberate or recklessly false statements or omissions. This is a high burden, and this is a very high hurdle for them to jump over. Now, if you can answer yes to that, then and only then should we move on. And then ask the second question, does that even matter? Does that statement actually diminish the probable cause finding? It's only when the answer to both of those questions is yes, should you then even consider granting a Franks hearing. The motion for a Franks hearing is a serious allegation. The allegation is that law enforcement acted improperly, that they lied to the magistrate in order to secure the warrant. The statements have to be deliberate, reckless, false. That's the standard. Franks is not implicated by just simple mistakes or misunderstandings about the evidence, or Scrivener's errors, or even just negligence. As the court is well aware, this is serious. The defendant is alleging law enforcement lied to secure the probable cause in this case. And the state submits the defendant has failed to back up this claim, and they failed because they can't. Law enforcement submitted probable cause affidavits to the magistrate based on the information they had available to them at the time that the various applications were made. That's how it's supposed to work, and that's how it worked. The defendant has alleged 13 separate areas where they say there's a Franks violation. I'm going to go through those so that I make sure that I get through each of them in the same order that defendant addressed them in their motion and as the state addressed them in our response. And that starts with this idea of attacking Exhibit A.
I am going to speed her up just a little bit because honestly, she talks a little slow for my brain. If
Thank
this
you.
is too fast, let me know. She's being very deliberate with her responses, which is great, but it's a little slow for me.
Court knows in Latah County, it's our practice, we submit an affidavit for probable cause. As I said, attached to that affidavit is what we call an Exhibit A. That Exhibit A is law enforcement officers' statements, laying out all the various facts known to them related to probable cause in order to support the issuance of a search warrant. In this case, Exhibit A, by the time we get to where we're challenging, was about 20 pages of facts for the magistrate to review. Essentially, the same Exhibit A was relied upon for the application of multiple warrants. This was a massive investigation. You heard testimony earlier today from Detective Payne. Multiple officers were involved in this investigation from multiple agencies. And they were doing briefings. For weeks at a time, they received 2 briefings a day with all the lead investigators in the same room receiving the same information. This information was then put into this Exhibit A for the basis of a probable cause affidavit for search warrants. A working document like this, with the most up-to-date information, was the best way to ensure the magistrate was getting the most complete and accurate information. And defendant wants to take issue with this process. But
What do I do if the affidavit is attached to Detective A's submission? Is it Detective A's affidavit, right? And there's for purposes of my question, a material reckless statement in there. But Detective A isn't the one that made it. It was another person on the team, let's say the cast member expert.
well,
How does that affect the Frank's analysis as it relates to the affidavit submitted by Detective A?
I would say that Detective A would have to have reason to know that that was a materially reckless statement made by Detective B.
Even if the person that made the statement on the team knows that that statement going into the affidavit, the group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede I think there's an issue there, but that's not what happened. I don't think that any officer can submit a statement that they know is going to go in front of a magistrate and do so recklessly. And if they do so, then I agree that the court should take issue with that. But the cooperative nature of this investigation and this kind of group effort is allowed. As discussed more extensively in the state's response, we have several Idaho cases that support this. State v. Rubio, State v. Gomez, State v. Alger. And in our case, the probable cause affidavit, it wasn't as if the judge wasn't put on notice that this was exactly what was happening. The judge was put on notice. Each affidavit explicitly told the magistrate, blank officer, depending on who was applying for it, quote, is being assisted by members of the Idaho State Police and agents of the Federal Bureau of Investigations. Throughout the document, it makes references. I consulted with FBI Vehicle Specialist S.A. Imel. I consulted with FBI S.A. Balance regarding cast. I consulted with FBI S.A. Hill regarding surveillance footage. It's very clear what the sources of the information were coming from. It could absolutely be reasonably inferred where the information was coming from. The magistrate was not at all misled regarding the sources of all the information. I'm going to talk a little bit about this idea that there's some issue with who did the work in reference to Google. They claim that the CSLI work.
I'm going to skip forward a little bit here because she gets into more of the nitty gritty, boring stuff for a little while. Just a second. See where she's at here.
Who tells us, and that's what was relayed in the probable cause.
State to determine whether they have met their threshold burden. And so I get concerned when
the magistrate was never informed that DM told law enforcement she, when shown a picture, didn't recognize the defendant. Well, it's clear from reading the probable cause affidavit that she's not going to recognize the defendant.
What relevance was the statements of DM that were included in the affidavit as to probable cause?
I cited those in my response throughout.
What were they?
Okay. I can tell you generally, consistently, she gave the same set of facts.
I understand the things that she said. Why was it important the magistrate know those things? In other words, are they going to who the ID of the perpetrator is? Are they going to establish a timeline of when the alleged or when the murders took place? Okay, so it's part ID as well?
I think that it goes to giving a general description of the person that she saw in the residence around the time that corroborates when we know these crimes occurred. Yes, a general description is material and relevant. And that general description, which is what was provided in the PC affidavit, was consistent throughout all of her interviews. She described seeing someone wearing all black, a mask with only a portion of their face showing and visible. This person was male, white. She heard a voice that was not something that she recognized. The person was a slim, skinny, lean build. And the person was taller than she is around 5'8". That's what's important. It was that general description. And that general description did not change.
It's also important to establish the timeline.
It is. It's important to establish the timeline to know when that the timeline matched the vehicle surveillance of when a suspect vehicle is coming into the area of 1122 and then leaves, as well as text communications of her relaying what she's observing during the same time period.
So did you catch what she just said? As well as text communication from DM at the time that this was all happening. That's crazy. I'm going to go back and play that one more time.
And then leaves, as well as text communications of her relaying what she's observing during the same time period.
Let's think about that for a minute. Hey, 12 gauge, how you doing? Good to see you. So yes, the eyebrows for sure. Text communication. I want to hear that one more time.
And then leaves, as well as text communications of her relaying what she's observing during the same time period.
Well, we had always speculated on that.
Yeah. I had always said that in the PCA, it states that they did, forensic downloads of phones of Dylan and Bethany. Was she texting Bethany? Was she
That's what
texting
I've
someone
always wondered.
else? That's all going to come out at trial. But here's the first time that we're getting to hear confirmation that she was definitely texting somebody, relaying to somebody what she's hearing and seeing. That's
Well,
crazy.
I don't think it was law enforcement though, because they would have been there, but I wish she would have
Exactly.
text law enforcement. But
Texting
not everybody
DoorDash?
knows not everybody knows you can text law enforcement.
Right. Yeah, you can text 911 as well. But no, she wasn't. I don't think she was contacting law enforcement at that point. So who was she texting? What was she telling them that she was hearing and seeing?
Now, Bethany was not there.
Yeah, she was. She was down in the basement level, the ground floor level.
Okay, I've heard
She was in her
both.
room. She was there.
Okay.
The best of my knowledge, she was there. I
Well,
mean,
I always thought she was, and then I heard she wasn't, and it's like, okay, I don't know which one, but maybe she was saying, "Hey, stay down in your room, don't come up here. There's something going on,"
yeah. Yeah, I've always wondered about this too, Ellen. And that's all going to come out, in trial. All of those text messages that she was sending and receiving during that time, that's all going to come out. So we'll know at trial who she was texting and what she was telling them, because that's going to go to.
I'm sorry, hon, go ahead.
Oh, you're fine. Go ahead.
I was just going to say, are you going to be doing like catch up and review of a lot of this stuff in between now and August?
Yes, as we get closer, probably like in June.
Yeah,
I'll
I
do
think that would be good.
a few live streams to start catching everybody up that hasn't even seen the case at all.
Right.
A review from the beginning. I'll
It
do
was
that.
funny because even here in Kansas, where I live, everybody had been talking about this when at the nail salon when I was working there. People would bring it up when they found out that I was into true crime and all of that. It was amazing how many people knew. They even talked to my husband when he goes on jobs. He's in people's houses all day long, in and out. And there were people talking to him about it even. It was
everywhere
widely
for a
spread.
while.
Yeah, it
For
was.
at least a year, it was everywhere. And now it seems like, which is
Don't hear
natural,
anything. Yeah.
you don't
Right.
hear a lot about it. But now that we're getting, ramping up, pretty soon we're going to have more pretrial motions and hearings and all this stuff. It's going to really start increasing now. And
yeah, I think it would be good to go
once
over
they come to
some stuff.
that final, as soon as I can tell we're coming up to that final pretrial hearings, then I'll start doing some reviews, of the whole case.
I think that's a good idea.
Nice and short and sweet, though, just a review of all of the information.
Right.
But yeah, it's good to have confirmation that she was in fact texting somebody during this time. But it still doesn't answer why didn't she call the police? We all have that question. It's okay to have that question. It's not okay to then say, oh, she didn't call the police because she was involved. She knew what was going on and it was a drug cartel and she, you know what I mean? She was involved and knew and he was her friend and all this crap that you hear out there. That doesn't have anything to do with it. She didn't call police. Why? We still want to know that. Did she and whoever she was texting with decide it was nothing and then they just went to bed? Or did they calm her down? Was after that shock that she was in over seeing this weird individual in her house? I mean, lessons can be learned from whatever comes out at trial. You see something like that, you hear all these concerning noises, you really should go ahead and call law enforcement. Stay in your room and call 911 and have them come check it out to make sure that everybody is safe.
Yeah, I have trouble with her not calling the police, but apparently it made sense to her at the time.
Yeah. And I'm not going to judge her based on that. Unless hey, what if it comes out later that, she knew that maybe she saw, a knife or blood or something and still didn't call 911?
Yeah.
Then I'm going to be pissed.
I mean, I
But
think honestly, I think, I might text my friend downstairs and say, don't come up here. I don't know what's going on, but there's somebody in the house. But I can't imagine. I mean, my first thought would be to call the police.
yeah, totally. But we're also not 20 years old anymore, right?
No.
Their frontal lobes aren't quite fully developed yet.
This is true.
I have to give them grace for that, for their age. They're still kids to me.
Oh, yeah.
20, 21 years old. That's a kiddo to me. But yeah. So yeah, pretty sad. So let me continue here.
And even if the state's wrong, that somehow there was some exculpatory relevance to some of her statements not being included in the probable cause affidavit, you can take all of it out and the magistrate would still have probable cause. The second issue, defendant, the second kind of bucket that they take issue with DM is about these other just statements that she gives during her interviews. The defendant argues when an eyewitness states she's not sure anything she saw was real, a magistrate should know about it. Well, the simple answer is investigators knew what she saw was real, and we know it wasn't a dream because they found the evidence discovered the next morning. Those statements didn't need to be included in the PC affidavit because they weren't exculpatory. They didn't support this idea that this didn't.
So what she's going at there is trying to, explain to the judge, it's not exculpatory for her saying, I wasn't even sure. And it goes on to say, she adds in information here in a minute that DM stated that she'd had too much to drink and couldn't really remember and wasn't really sure if she was awake or dreaming or, what was going on. She didn't know what was going on.
That's why she didn't call the police right there.
Drunk. Yeah, she could have been, who knows? I'm just speculating. I'm not judging either. She could have been high too. We don't know. She could have been freaking out over, maybe she thought she was tripping. You know what I mean?
Yeah, exactly. If she didn't know if it was real or not, she wouldn't want to look like an idiot calling the cops, right?
Exactly. Right. Yeah. And some people, I would probably be one of those if I ever tried pot, which is what I never did. There's a lot of people who have paranoid trips, or maybe she thought, oh my God, that
strain, a
bad trip.
Laced with something.
Laced with something. Exactly. Maybe she thought this can't be real, and maybe that's what she was trying to explain to in her interviews. Like, I didn't know. I thought maybe I got hold of some bad weed. You know what I mean?
Right. Exactly.
She could have been saying that. All that's going to come out at trial. I think there's going to be reasonable explanations for everything once we hear it. I don't think it's going to come out that she knew anything relevant. And by what she means by they didn't tell the magistrate what she was talking about here, because it wasn't exculpatory. She didn't tell law enforcement, oh, I saw a blonde guy with blue eyes.
Right.
And law enforcement left that out of the PCA. That would be a deliberate omission. She didn't say, I saw a red car and there was a blonde lady driving it and he hopped in. All of all that stuff would be exculpatory. Anne's trying to twist her words is what she's doing. And I find that offensive, in my opinion, to do that to a victim, because she's a victim too.
I
And she's
completely agree.
damn lucky to be alive for as many times as she opened that door and peeked out. She's lucky, very lucky.
Honestly, I
Ugh.
think those neon signs that they had, I think those were enough to, because those things are bright, man.
Yeah.
I think that might have been one of the reasons why he didn't see her.
Yes, and he also had that, what was that called again?
Snow,
The
that
vision, snow,
snow, I forget what they call it, but it was snow something or
visual
other.
snow.
Yeah.
He probably had, a bit of tunnel vision at that time. He was very focused on getting the hell out of there, and
Yep.
he probably wasn't looking around. He had no idea anybody else was there.
Right.
He was probably circling and watching and looking around, and her light was probably off. He didn't know she was there. Or she wouldn't have lived to tell what she saw. So,
I agree.
but she's right. They could have just left all that out of the PCA. I've said that from day one. I don't think they even needed to include anything from DM in the entire thing. I really don't think they needed to include anything from her. The only reason that they did, and the state answered this kind of poorly, in my opinion, was he was asking her, why did they even include anything from DM? Because he could tell that it wasn't even necessary. And I think that they put her in there to establish that footprint that they found outside her door. It was just another connection, that they were trying to make to him. And I think they should have just left it out. Because all it did, putting her in that PCA, was make her a target. That's all it did.
True. That's very true.
It really happened. That somehow we got it wrong. Next, defendant attacks the vehicle identification. Well, this picture they're painting about how this happened just is simply not true. The magistrate was given a very detailed picture of the investigation at the time related to the white sedan, which was later determined to be a Hyundai Elantra. This was about 5 pages of the probable cause affidavit. The reality is, yeah, still images and video were provided to a vehicle specialist. Based on his review, he provided information to investigators that the suspect vehicle was likely a Hyundai Elantra. There was some discussion regarding what was the most appropriate year range, but at the specialist's direction, he said that the year range to be focused on was 2011 to 2016. So Detective Payne reasonably relied on his expertise as a vehicle specialist and included that in his probable cause affidavit. And the court has in front of it the emails attached as exhibits that show that's exactly what occurred. And the defendant appears to argue that, well, the vehicle specialist shouldn't have relied on this video because they can't tell that that was a Hyundai Elantra. To them, it doesn't look like, I guess, a Hyundai Elantra. And the video that is clear, well, they take issue with that video because, and specifically, we're talking about 1125 Ridge Road, because they say, well, that can't be surveillance video of the white Elantra, even though it was caught on video about 0.3 miles from the crime scene, about 3 minutes right before when we see the suspect vehicle enter the area of the crime scene.
So at this point, I'm going to pause for just a second. I'm going to pull up the map and show you guys what she just referred to. Because I took that address, the 1125 Ridge Road, and pulled it up, and you can see where it was. Just a second here. 1125 Ridge Road. Here it is. So if we pull this up, this is the house. It's actually not a house. I'm going to go around the back real quick and show y'all. It's an apartment building. So if you go to the front, and I was over on 12 gauge last night, we were talking about this, looking, see where's the camera, that they caught the clear image of his vehicle.
Mm-hmm.
And I was looking around. I was like, where is it? Where is it? It's not on the house anywhere. I couldn't find it. And then I went, look at this pole. Let's look up. Bam.
There you go.
There's the camera. So, and where is this house located? Here's the house over here. So, in the PCA, it describes his route of coming into town and coming down Taylor. Well, he mapped it all out last night. But coming by here, there's that A&W, and he's seen as he's coming down here, probably right here. And coming over Taylor and then all the way down to the house. And then he's seen again looping out of the neighborhood. So this is the camera right here that caught him
It's a good
coming
angle.
this way from that corner right there.
Wow.
And this is a 3-minute drive as he was seen coming into Queen Road. It was right there. Like you could almost see house to house.
Wow. It's a very good angle.
Yeah. And there's a whole bunch of other cameras that caught still images and videos and stuff. But this is the one that they said that law enforcement said was a really good image. A good image of the vehicle. So they got him.
That means he probably could see him too.
So then Ann Taylor goes and admits, let's see. I'm going to go back to the video here. Just a second. I learned, didn't I? Close my stuff before I switch screens. It's easy. Oh, thank you, Ellen. I appreciate that. So yeah, that's how close that they were, that he was seen. And remember the alibi, y'all? Wasn't his alibi that he was in a completely different direction that whole night?
Didn't he say he was in a park or something?
Yeah, Wawa Way Park,
Yeah.
many miles away, out stargazing and looking at the moon.
Mm-hmm.
She admits in this hearing, and I'm going to get her quote. I'll let her say it, and I'll point it out. She admits that he was there. Watch this.
Wow.
Oh, good grief. I didn't even reshare the screen, y'all. Hang on.
I was getting ready to say,
Were you able to hear any of that?
no.
Oh my God.
I was getting ready to ask you if you were muted or something.
Sorry.
If it were, then the surveillance right up the street
Hold
would have
on.
also caught this. Can't be the right to be for when we see the suspect vehicle 3 miles from the crime
There we
scene.
go.
About 3 minutes right before when we see the suspect vehicle enter the area of the crime scene, which 0.3 and 3 minutes appear to be the amount of time it would take the vehicle to travel to the area of the crime scene. They say, well, that can't be the right video.
Yeah, I don't nod off on my streams.
At least you didn't fall out of your chair.
Not going to see me hitting my mic with my nose.
Or your 50-pound mouse, go flying.
Okay.
Because if it were, then the surveillance right up the street would have also caught this video. But we know that's not true. And that's been submitted to this court. Excuse me?
When was it submitted to this court?
Well, it was submitted through my response.
I was afraid that you were going to say.
It was submitted through my response that their logic is flawed. And I can tell you, it has since been confirmed. I do not have and it has been discovered to defense. We had Special Agent Hill confirm, and he discovered this as Bates 15990, which confirms that the surveillance camera that was set up to capture motion would not have captured the corner the defendant says must have been necessarily captured. Again, it doesn't matter. At the end of the day, the defendant's speculation about the route of travel and their differing opinion on it isn't the basis for a Franks hearing. There's no legal basis for second guessing a vehicle specialist's opinion. And they haven't made a substantial or a sufficient proffer for you to do that. Next, the briefing addresses the IGG issue.
Is it possible to tell from the affidavit what shots and what cameras were relied upon to make the identification?
I know that I don't know that you needed to. I don't know that all of that information had to be included.
That wasn't my question. My question is whether the affidavit describes the specific shots and cameras relied upon to make the identification.
No. It discusses that several surveillance videos were reviewed, that images were turned over to a vehicle specialist, and then that specialist made a determination. But no, we didn't walk through describing each and every still image or video to the magistrate. No, nor did we need to. Really, the IGG has been discussed extensively. I think the only real Franks issue is, should the IGG process, the fact that it was not included in the PC, is that the basis for a Franks hearing? But you heard testimony today that law enforcement received this tip and they made a strategic decision not to include it. They were told it's only a tip and that they should develop probable cause separately. And that's what they did. And at the end of the day, Your Honor has already hit the nail on the head through your questioning of Ms. Taylor. At the end of the day, this information regarding IGG and the use of IGG is only inculpatory. And the non-reliance on the IGG information does not diminish probable cause. And the IGG information was confirmed through the SDR testing. I can't wrap my head around any argument that IGG and SDR testing would be exculpatory. Defendant makes
Okay, so this next section is kind of long and boring, so I'm just going to kind of recap it. They go over the 2 traffic stops from 2 months prior to the murders. And Taylor tried to say that they were put in the PC to bolster a false investigation. The state said no, it was not. That it was put in there. Let's see. Ann Taylor called it stacked circumstantial evidence. Then the state said no, the traffic stops were submitted to show that the license plate was missing on the front of the car. You know, he got the front license plate just days after. So yeah, plotting for sure. Let's see, because his car was still registered in PA. So that's why there was no front license plate. And so it was to show the connection there. That's all that was. There was a lot of stuff in the PCA that didn't even need to be there, period. Let's see. So again, Ann Taylor's trying to suppress AT&T warrants 1 and 2. The first warrant was for 24 hours. And then when they got that back, they, verified his location and calls and all kinds of stuff. And then they came back and did 6 months for his phone. And that they got a lot of information from that. They had to have gotten a lot of information because Ann Taylor's trying to suppress it. She wouldn't be trying to suppress it if there was nothing there. Okay, and then let's see. Because of the AT&T warrant 2, that's when they got the warrants for his arrest and for his DNA. They got the search warrant for his apartment, for his car, and for his parents' house. So that's why I was saying the reason that they want to suppress AT&T warrants 1 and 2 is because if they can get those suppressed, then the warrants for his arrest, his DNA, his apartment car, and his parents' house, all out. Because they would be fruit from a poisonous tree.
Right.
That's why she's going so hard with those first 2 warrants. And then, let's see. And then here's where she says, and I don't have the timestamp on this video, darn it, but well, hold on. I'm going to actually go pull up the stream and play this one section here. Just a moment. Because this is where she actually says that he did go over there. That one. Let's see if it's still on the judge's YouTube. It's not, so let me go to Law and Crime.
I really like this judge.
Yeah, he seems to be very no nonsense.
Yeah, and he's also very fair. I mean, he's just as equally hard on one as the other.
Yeah. Let me move my notes so I can type here. So I've got the timestamp. Oh, let me go to my history because I've got it in my history. Be quicker to find it. The whole day, was recorded.
Right. Sorry, I'm eating some peanut butter out of the jar. I needed some protein.
Well, there you go. History. Here we go. I want the 8-hour one because it was like 5 hours of nothing on the screen.
Really?
Yeah, the whole day. It was this portion of the hearing is closed. This portion of the hearing is closed.
Oh.
It wasn't until the last 3 hours that there was anything on the screen. I just had it sitting up on my TV all day long, waiting and waiting and waiting.
No sound, no nothing?
No, nothing.
Wow. That's a long time.
Oh, no, that's not it. Here it is. I believe this is it.
Yeah, I do believe he was plotting. When this first happened, when I first said, let me know when you get it, hun, I'll shut up. When this first happened, I was saying, that I believe that he was studying SKs and all of this because he knew what he wanted to do. And people are like, well, where would he find that out? I'm like, what, YouTube?
Right.
You got so many of these guys that study and study. And also we have to remember he was also he studied communications a lot too.
Yep. And forensics, the cloud, he was he had a degree in cloud forensics. Okay,
Yep.
here I found it. I'm going to play this for a few minutes here. This is where she changes the story a bit on that alibi.
Apartment, the lack of connection to the individuals.
What is that? Even if disclosed, preclude a finding of probable cause when there's a DNA match between the DNA and the sheath in Mr. Kohberger. Isn't that probable cause every day and twice on Sunday?
I love that.
Not in this context, because of the IGG work. Because
did I go too far? Hold on. I have my note written at 6:53 is the timestamp. Let me go to 6:52. Hold on.
he wasn't connected to that house, to the people in the house. Your Honor, I'm,
Maybe I'm thinking of a different date for the AT&T. I thought, not the cell tower stuff. So you're still talking about the cell tower stuff?
no, I mean, that stuff applies to every single warrant we have because that was
I thought you
early.
transitioned to warrants that were obtained after the arrest.
I did.
Yeah, and by the time of the arrest, they had a direct DNA connection.
Your Honor, what I'm talking about,
Some other evidence that the defense can claim in cross-examination or their own case is exculpatory, but isn't the DNA connection in and of itself probable cause to support any of it from there?
Your Honor, the DNA I'm talking about is the lack of DNA in Mr. Kohberger's car and the lack of DNA in his apartment, the lack of connection to the individuals.
What is that? Even if disclosed.
I've got this quote written down, and it was a little bit before that because I've got that, what she just said, written down after. So
Okay.
sorry. I'm going to have to go back in a couple minutes because I want you to hear exactly what she said.
D1B and C, that's an email from Nicholas Balance, and he's talking to the detective in Moscow about the dates that he says this thing happens. His cast final dates on those about that is that it's misleading. Moscow has cover from the records, you stationary or not. You can know whether it's parked, looking at a particular place or not. Based on those records, we also provided the records just so the court would know there's a volume of records. I don't expect the court to decipher those records. But based on those records, they absolutely knew that Mr. Kohberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They absolutely knew that that's not what was happening, but they put it in there to make a connection that didn't exist. They put it in there so that the judge would think that this was the right person, and they shouldn't have done that. They knew that was incorrect. They also
Yeah, here it comes.
changed that quite a bit, performed a drive testing, and so there were other bits of data that kept coming in so that they would know that was untrue. Now, for a magistrate to be relying, remember, on somebody who's a witness, somebody who's been interviewed 4 or 5 times, and continually says something that's absolutely impossible, has memory problems, and the judge never knows that, and we'll keep the IGG identification off to the side. But then you have this false narrative that looks like stalking, that looks like following, and it's not true. That is extremely damaging. It's very misleading. It's an outright lie to the magistrate. When you omit that kind of information, when you take that context out, you might as well say stalking because that's what you're trying to say, and you know that's not true. This court can rely on our proffer in D1B and in the cast draft report and in the cast final report because those dates change. The court can rely on the evidence that will be produced at a hearing from defense experts that will talk about the handoffs, the patterns of handoffs, and how misleading that paragraph was to the magistrate. The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And
So right there is where she said, he did go to Moscow. He did drive around, but he didn't go over there.
Well, they got
Okay,
him
but-
on camera.
But they have him on camera 0.3 miles away, 3 minutes away at that corner. I mean, come on, Ann. Come on.
It's stretching a little bit there.
Yeah. And she keeps trying to bring up the fact that they didn't find any DNA. So after this, she says, oh, but he only had 13 minutes of time to do the crimes, and there was nothing found in his car. Well, they didn't search the car for 6 weeks until
And he
after
had
they.
cleaned it and washed it with bleach, I believe.
Mm-hmm. Oh yeah, he probably didn't use bleach because that can be detected. He probably used something else.
Well, he would know what to use.
Yeah, and he would have all of those tools and the UV light, and he had 6 weeks to
Mhm.
do this. And then, let's see, 650, 659. Right here, I think it's another little clip I want to play.
The victims and not some earlier event in the house.
If, and what the court is saying is exactly why the magistrate needed to know that. Is there another explanation here? I've got this sheet, but there are all these other things that if I know about them, matter. What's the other explanation? What's going on with this investigation? What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence. She wasn't given a chance to ask any of those questions. She didn't know that Bryan's car, and the court's question, good question, what does that mean? Could it mean there's more than one person? The answer to that is, or it could mean it's not Bryan because his car's got nothing in it and there were only 13 minutes to do this. The magistrate didn't get to know that.
In fact, his DNA is still on the knife sheath, though. That's the problem, counsel, for probable cause purposes.
If that's the only thing she's told, I can see why she'd find probable cause. It's these other things that are withheld that create a context around it. I think the purpose of Frank's is to ask this very question. This is a question. What do we want to do with our criminal justice system?
Okay, so this isn't the same darn link because my timestamps are off a little bit. Let's see, unless they went back and edited it. Okay, so again, she says, there's like 13 minutes and nothing in his car. And the judge said at that point, well, his DNA was on the knife sheath. Does any of the other stuff matter when there's a direct connection for purposes of arrest, not conviction? That is enough for probable cause. And let's see. The state then gets up and says there's no proof of any deliberate, reckless, or false omissions by law enforcement. The defense hasn't shown any of that. No evidence whatsoever. And all of these little details aside, take any of those out, and there's still doesn't diminish probable cause. And let's see. There was some more stuff about Dylan and how she described him. She really just went hard on her. Let's see if there's anything else in here, because it was pretty much wrapping up at this point. They did go a little bit into the Amazon as well, because Anne is trying to get the Amazon warrant thrown out. There's probably a lot of proof in that Amazon warrant, maybe an order for a knife or a sheath or something there. And that was a grand jury subpoena. It wasn't from law enforcement. Originally, they went back and did their own too. But originally the first one, or maybe there was an additional one if I remember correctly, because the grand jury wasn't until April or May. And I believe there was Amazon. I'd have to go back and look. There's probably Amazon warrants before that. But the only last thing that kind of had me going, Anne is just really going after DM, and she's going to attack her in every way she possibly can, was that because in a couple of Dylan's first statements to police, she said that she heard one of the victims, Kaylee or Maddie, run down the stairs around 4, around the time that is in the PCA where she mentions that it sounded like somebody was playing with the dog upstairs. She also had said that she heard one of the victims run downstairs and then back up the stairs. She didn't say she saw them. She says she heard them. And that is what Ann Taylor was saying. Well, that couldn't possibly be true. Well, we really don't know that, do we? Do we really know?
It isn't the stairway right by Dylan's room.
Mm-hmm.
The stairs go right up like 2 feet away from her or something.
Yeah, it's right there. So she heard somebody, going up and down the stairs, and maybe when she discovered, that her friends had been killed upstairs, then she's wondering, was what I heard real?
That really
could have been,
happened, yeah.
did that, you know what I mean? She's second guessing herself because it happened at the same time around 4 a.m.
Well, and
So-
two, if you're high, because I have
Drunk.
I have inhaled and I have drank before. So when if she did smoke some, and apparently she'd had a lot to drink, but usually one goes along with the other in college. Your mind has a way of, you think about something and then it you have to kind of grasp that thought again too, because it'll
Yeah.
disconnect for a few seconds, and you're like, what,
And you
what
have
was
kind
that
of-
again?
You kind of have a warped sense of not just your senses, right? But a warped sense of time and place,
Exactly.
So she was probably super, super confused as to everything that she saw and heard. But even if you took everything out, which it shouldn't have even been in the PCA in the first place, in my opinion, even if you took all that out, the judge is saying you still got probable cause.
Yeah, he keeps going back to that sheath.
Uh-huh.
Yeah.
So yeah, that was pretty much it for the hearing. He said he would take all of the information under advisement, and then let me go back over here because the hearing for today just started a couple hours ago. So now I'm going to go back and watch today's hearing. And I thought about just kind of skimming through here now with everybody, but I'm just going to watch it on my own and take more notes and stuff, and then maybe do a live tonight or tomorrow or something, especially if something extraordinary comes out, because today's hearing is the evidentiary hearing, so there's more that's going to come out today. So I'm definitely going to start watching this and do all my household chores and watch and take notes and my usual stuff for the day. So so much came out. There was little, just several bombshells, about Dylan and this extra blood. And
I tell you what, what I've heard today with Dylan has answered a lot of questions for me, honestly.
Yeah, it definitely explains a little bit more.
Yeah.
But they're trying to not let a lot of it come out just yet, but things are slipping, and we'll learn more and more and more as we get closer. So,
well, thank you for having me up. I'll go ahead and get down. You can say goodbye to everybody, but I've really enjoyed it today.
Thank you so much. I appreciate you. I love you very much. You're
love
awesome.
you too, sweetheart. So are you. I'll talk to you guys later. Bye-bye. Love
Bye.
y'all.
Bye. Well, thank you, everybody, for being here. Appreciate you so much. You have a great day. I'm going to go watch that hearing, and I'll see y'all next time. Have a wonderful day and a great weekend coming up. I hope your weather is warming up a little bit where you are. It is here a little bit. It's still too cold for my liking, but I'll have a good day. I'll see you later. Bye.